Hello, and welcome to this installment of the Pro Bono Partnership of Atlanta's webcast series. I'm Sarisha Gunta, Education Director with PBPA. Today we have two wonderful speakers to talk to us about UBIT, Unrelated Business Income Tax. Madeline Obler is Managing Counsel with the American Cancer Society, where she advises her client on tax-exempt related matters such as UBIT. And Robin Miller is Senior Corporate and Tax Counsel with the Pro Bono Partnership of Atlanta. Several of our viewers may be familiar with Robin, as she regularly advises PBPA clients and speaks on tax and corporate matters for Georgia nonprofits. I'm looking forward to hearing all the great insight that they're going to share with us on UBIT and why UBIT is, in fact, not a four-letter word. But before our speakers get into the substance of today's presentation, I would like to share a bit of information about PBPA and our mission. Pro Bono Partnership of Atlanta provides free business legal services to Atlanta area nonprofits. We connect small community-based nonprofits with volunteer attorneys from law firms and corporations. PBPA provides legal insight relevant to small Georgia nonprofits, striving to meet nonprofits where they are in their journey and capacity. For example, we provide services to startups through our nonprofit bootcamp and one-time engagements like our vital signs form clinics and ongoing one-on-one legal counsel to nonprofits that qualify as clients. And our Learning Center. Our Learning Center is full of podcasts, webcasts, and articles, and these are available to anyone for free and are tailored specifically to small Georgia nonprofits. If you have a legal question related to a nonprofit, you can probably find the answer here in our Learning Center, so keep it in mind. And now to share a little bit about clients and client criteria for PBPA. Our clients are all 501c3 organizations that are headquartered or primarily working in Metro Atlanta, have one staff member, and they serve disadvantaged or low-income communities. If you are interested in learning more about becoming a client or in applying, please visit our website. And now a little bit of housekeeping. Keep in mind that the information that Madeline and Robin will be sharing with you today is general information. And today's webcast is copyrighted. I will share the slides with everyone momentarily. And this video is being recorded. We welcome your questions during your presentation today. Robin and Madeline will try to answer them all by the end of the program, as long as they're within scope. So please use the Q&A function to pose your questions. But first, I would like to pose a quick question to you, our audience. And this will help give Robin and Madeline a little bit of insight into the viewers today and if and how they might have UBIT questions. The poll should have popped up on your screen, so well, there we go, Madeline, Robin, a pretty even split within our audience. And I'll let you guys take it from here.
Thank you, Sarisha. I appreciate your introduction this morning. And thank you, Madeline, so much for speaking with me today on this topic. I really appreciate it.
Thank you for having me.
Oh, my, very much appreciate it. So our agenda for today, we're going to cover sort of three different topics. First, we're going to talk about what is unrelated business income and why is it important. Then we're going to turn into unrelated business income is codified in the Internal Revenue Code, and there's all kinds of regulations associated with it. And within the code, there are exceptions, exclusions, and modifications to what constitutes unrelated business income. So first we're going to learn the rule, and then we're going to learn some of the exceptions, exclusions, and modifications, because there's a lot of them and they get pretty complicated. But we're going to try and cover some of those that would apply to our small nonprofit organizations that we serve. Then we're going to also talk about some specific revenue generating activities and the potential for unrelated business income generated from the generation of that revenue. And we'll get into that in a little bit of detail. But let's start by explaining what the heck is unrelated business income and what are its implications.
Sure, thanks, Robin. So unrelated business income is income that is from a trade or business that is regularly carried on and that is not substantially related to the purposes that form the basis of the organization's tax-exempt status. The purpose of enacting UBIT, which was back in the 1950s, was to provide a level playing field for tax-paying businesses so that tax-exempt organizations could not use their privileged tax status to unfairly compete with tax-paying businesses in activities related to their purpose. There's a common misconception that I've seen that if an activity qualifies as unrelated business income, that a nonprofit cannot participate in that activity, and that's not the case. Nonprofits can engage in unrelated business activities, but might be subject to tax on the income produced from such activities, and that's unrelated business income tax. Many nonprofits you'll see avoid unrelated business income generating activities because they want to avoid paying the tax. The tax is relatively substantial. It's the 21% flat federal corporate income tax rate. Next slide, please. So it's important to note that not all business income is subject to tax, only unrelated business income as defined by the IRS. So when we're defining unrelated business income, we're looking at three different conditions. And if any one of these three conditions is not present, then the activity will not be taxable. I really can't emphasize that enough because I've seen clients who get confused when they meet only one of these three conditions and they still think that they owe UBIT, and that's not the case. The activity needs to meet all three of these prongs that we're about to discuss in order to be considered unrelated business income. So again, breaking down these three prongs, unrelated business income must be from a trade or business. So that's an activity that's carried on for production of income from the sale of goods or services. Something that's regularly carried on, that's the second prong. We'll get into a lot more detail about this, but this is an activity that has some continuity, like a typical commercial activity that you would think of. And finally, the third prong is that it's not substantially related to the organization's tax-exempt purpose. That means there's no causal relationship to the organization's exempt purpose. It's important to note, and I'll say this again because it's that important, the mere fact that income produced will be used to carry out the organization's mission is not enough to prove a causal relationship. The activity itself has to be related. So just because the income you're generating may just go right back into the organization, that doesn't make a difference if that's the only thing that's creating that relationship. The activity itself would need to be related. So starting with the first prong, which is trade or business, this one is probably the most straightforward of the three. An activity is usually considered a trade or business if it exhibits an intent to derive profit from the conduct. So we usually see this prong satisfied when there's a sale of goods or services. I also want to note that intent for this prong is really important. If the intent is only to recover cost and there's no realized profit that exists, the activity is considered to lack a profit motive and may not be considered a trade or business for this purpose. So keep that in mind when you're considering this first prong. The second prong is that the activity is regularly carried on. So this can be a little harder to determine because whether something is regularly carried on for purposes of UBIT really depends on the surrounding circumstances. The IRS primarily considers the frequency and continuity of the activity and the manner in which it's pursued to determine if it's regularly carried on. Again, UBIT only applies to income from a business activity that is regularly conducted, as distinguished from something that's just sporadic or infrequent. One of the tips which we have up here for determining if something is regularly carried on is to measure the frequency of the activity against the frequency with which a commercial enterprise would conduct that activity. So normally activities that are only taking place over a period of just weeks or a few days are not considered regular for UBIT purposes, especially if the activities are normally conducted by a comparable for-profit business on a year-round basis. So for example, if a nonprofit were to hold a bake sale, let's say, maybe once or twice a year to raise some extra money, this is not considered regularly carried on. It's just sporadic a few times a year. And if we think of a comparable commercial enterprise like a bakery, bakeries are open daily, 9 to 5, so a few days a week as compared to the commercial enterprise of a bakery open daily, not comparable and not regularly carried on. Oh, actually, can you go back for a second? Sorry about that. So just hitting on this one more time, an activity is not considered regularly carried on. Just a few indicators of that. If it's infrequent, if it's only conducted for a short period during the year, or if the activity is not engaged in with a competitive or promotional intent. As I said before, activities over a period of just weeks are not regular, especially if the activity is of a kind normally conducted by a for-profit business on a year-round basis. But that said, it's really important to note that year-round activities would be considered regularly carried on, even if they're only conducted one day a week. So if you have a regular income-producing activity that's the exempt organization is doing once per week, but this goes once per week for the entire year, this is likely considered regularly carried on. The other one I want to note is seasonal activities. Seasonal activities can be considered regularly carried on, even if they're conducted for only a short period in the year. But we have an example coming up that'll highlight this point. So now I'm ready for the next one. Perfect, thank you. So the last prong is whether an activity is unrelated to the organization's tax-exempt purpose. To be a related activity, the conduct of the activity must contribute importantly to achieving the purpose or mission of the tax-exempt organization. I'll say it again, how the funds are used is not a factor. So the mere fact that an activity generates a source of funds that then go back into the nonprofit to carry out its mission does not mean that the activity itself is related to the mission. I think examples are helpful in this situation. I handled a situation with a religious 501c3 that was approached to consult on a movie that was related to its denomination. The production company was going to pay the C3 for its consulting services. So of course, this raised the UBIT flag because the movie itself didn't promote the nonprofit's mission and it wasn't about the nonprofit itself. So this activity was clearly unrelated to the organization's religious purpose. That said, even though I'm using that as an example to show when something is unrelated, in this particular instance, this was a one-time thing. So the religious organization was not regularly consulting on movies and receiving income from it. This was a one-time thing, so it wasn't regularly carried on. So it didn't meet prong number 2. And so the income from that was not considered unrelated business income, and the income was not subject to tax. The last thing I'll say about this is that even if an activity meets all 3 of these prongs and is considered unrelated business income, it might still be exempt from UBIT if it meets an exception or exclusion, which we're going to go over in just a few minutes.
Thanks, Madeline. So now we want to turn to our first example, and Madeline alluded to this example a little bit. So you've got an exempt organization that derives revenue from distribution of holiday cards once a year. Is that considered taxable, and would it generate unrelated business taxable income? And the answer is, in this particular case, yes. But it's really important always to look at the why and what led to that determination. So this was an actual private letter ruling that was submitted to the Internal Revenue Service. And so you always have to walk through the 3-part test that Madeline just identified. So we want to look at, well, was it a trade or business? Was it regularly carried on? And was it unrelated to its mission? And so the facts in this case were that you had a nonprofit 501c4 actually, but the rules apply the same, whether it's C4 or C3 in this context, that hired a company to sell Christmas cards for it on its behalf. And the Christmas cards, the company that was selling them, which is a commercial co-venture, was selling them, they had received the organization's membership list, and they were selling these cards and sending them out to all of their members. The cards were $3 a box. And they said, either send us the $3 or return the cards to us. And they had a contract with this company to do this, and they were getting paid so much per set of cards or box of cards that were sold. So these specific facts are interesting. And so you have to break it down based upon these facts. So first, was it a trade or business? Well, it was definitely determined to be a trade or business. They had actually entered into a contract with a commercial company that sold Christmas cards. So definitely a trade or business where they were hoping to make money. Now, was it regularly carried on? Well, as Madeline pointed out, if something is seasonal and it's done in the same seasonal time frame that a for-profit business or commercial enterprise would conduct that activity, then it is considered to be regularly carried on. So in this case, they were selling Christmas cards during the season when Christmas cards are normally sold between August and December. And there's actually a Treasury regulation that covers specifically that kind of seasonal activity, where that would be considered regularly carried on. So then the last question, of course, on our 3-part test is, well, was it related to the mission of the organization? Well, potentially it could have been. You look at the American Cancer Society that sells birthday cards, and in their birthday cards, they talk all about, the American Cancer Society, but also they give individuals tips for living a healthy life to avoid having cancer. And so that is mission driven. What they're trying to do is spread their message and educate people about cancer and its risks and how to live a healthy lifestyle to hopefully avoid cancer. In this case, there was none of that. There was no mention of the nonprofit organization. There was no messaging of any kind. And so there's no relation between the selling of these Christmas cards and this nonprofit organization. So as a result, you had a trade or a business that was in fact regularly carried on and was unrelated to the mission of the organization. And so the Internal Revenue Service said, yes, this is in fact unrelated business income. Now, could the organization continue to do this? Sure, it could. It just needs to pay the income tax on the net revenues from the activity, amounting to 21% of those net revenues. Now, that's a factor to always consider is, can you make enough money off of these activities that you could pay the income tax and still generate revenue? And that may be a good way for the organization to generate some revenue. Let's turn to our next example. Our next example is one that's a little bit close to my heart. A nonprofit law school purchases a spaghetti factory. The revenues from the spaghetti factory are used to support the law school's exempt purposes. Is that, in fact, taxable? Well, turning to the next slide. It was. And in this case, we're talking about my alma mater, NYU School of Law, who in the 1940s purchased a company that owned the stock of the Mueller Spaghetti Factory, or the Mueller Spaghetti Company, I should say. And the question was, well, is this generating unrelated business income? Well, we walked through our test. So you had a trade or a business. Clearly, it was a trade or a business. It was a spaghetti, company or noodle company. It was regularly carried on. This factory was operating every day. And the manufacture of pasta products is not at all related to the School of Law and educating law students to become lawyers. So clearly we had all three of those. But what's really interesting about this scenario and this example is that the IRS sued NYU and won, and ultimately they had to sell off the spaghetti factory, which I will get to in a moment. But it led to, because it was the 1940s in New York City, and we're talking about a spaghetti factory, and there were many others. And so while they owned it, a lot of these other factories and companies were very upset because it was, they could charge a whole lot less and still make a lot of money. And at the time, the tax rate was different than it is now. So it was a great way for NYU to not have to pay a whole lot for, they could reduce the cost of the law school, they could make a lot of money, and they could put their competitors out of business when it came to pasta. So Congress got wind of this, and there were hearings in Congress around this issue. And they said essentially that, look, this is a tax shelter that's unfair. How can a 501c3 organization have these business activities that have nothing to do with the charitable mission of the organization and make a whole lot of money? And because they're not paying income tax on that activity, they could put a lot of other businesses that they competed with out of business. So that's how the unrelated business income section of the Internal Revenue Code and the Treasury regulations came about, was through this example. But another important factor here was the size of this spaghetti factory. Basically, you had this small little law school and this large company. And so essentially you have an activity where the tail is wagging the dog, the charitable dog, as it's put on the slide. So essentially they said, well, you have too much unrelated business income, and you are really no longer a charity that happens to be conducting some little unrelated business. You have this huge business that happens to be running a small law school in size comparison. And so they said, if you don't sell off your shares in this company that owns the spaghetti factory, that you will lose your tax exempt status because you are no longer primarily or substantially running a charity. And so it's okay to have some unrelated business income activities, and if it helps generate income to, after taxes to support your mission, that's fine as long as you're paying those taxes. You just can't have too much where you're no longer primarily conducting your charitable, educational, religious, and so on activity. And so that's what you need to keep in mind. Now, there's a whole lot of exceptions and exclusions to unrelated business income. And we don't have time to go through all of these in great detail. Madeline and I could spend days talking about the exceptions and exclusions to unrelated business income. So we're going to do it at pretty high level and share our thoughts on some of the ones that are fairly common to our clients at Pro Bono Partnership of Atlanta. So let's start with volunteers. If a business activity, one of these activities that is a trade or business regularly carried on and unrelated to your mission, if that activity is conducted by volunteers, 90% or more of volunteers, then it's considered actually not to be considered a trade or a business because it's not really competing. If it only survives because it has volunteers, almost all of its activity is conducted by volunteers, then it wouldn't be a viable trade or business on its own. And so in that case, and because charities can have volunteers, and they don't have to pay them, which is unique and different from a regular trade or business, that this exception exists. We call this the Girl Scout cookie exception because that's a really good example of a situation where you have almost exclusively volunteers operating and selling essentially a commercial venture. The next one we want to talk about briefly is for the benefit and convenience of members. There are not as many of our clients that run into this issue, but I think it is important to cover in the context of unrelated business income. So hospitals, for instance, often have a cafeteria. And that cafeteria usually exists for the benefit of the patients, their family members, and the employees of the hospital. Because their schedules are really busy, they may not want to leave the facility and go out and come back. And because they want to be close to their, if they're family members, they want to be close to their family that's in the hospital. So usually cafeterias are considered for the convenience of the members or the employees. So it's not just members, but it can be for the organization, for its employees and clients. Now, I had a client once that was in a small town. It was a hospital, and it had this incredible chef in their cafeteria. And people used to come into the hospital just to eat dinner there. And they actually started to take reservations for people to eat dinner there. They would keep a portion of it available to the staff of the hospital and to people that were visiting the hospital, but they did actually take reservations. So in that case, it's not really there for the benefit and convenience of the employees and participants in the hospital. And so that's something that you do have to be a little bit careful when you're talking about that. When you're talking specifically about members, you're thinking of things like, do they get some information from the organization? Maybe they get some kind of token, booklet or other information. Think about, AARP that may offer certain advantages to their members, things that are for their benefits or conveniences. In many cases, would not generate unrelated business income. But you have to look at each one of those scenarios very carefully. The next one is, and Madeline, jump in with any comments or questions as I'm going. I know she's dealt with all of these issues as well, and I love her additional thoughts as we go. Contributed property. Well, the most common example of that is a thrift store, right? So a number of our clients receive donated property and then they resell it in a thrift store. But what is interesting that a lot of organizations don't realize is that 90% or more of that property must be contributed. It must be donated property. So you might be able to, in your thrift store, sell on consignment some jewelry, but it can't be more than 9% of what's sold in that thrift store. Because if it is, everything sold in that thrift store becomes unrelated business income. And the concept again here is that this store or the things that you're selling is only viable because you've had received these goods through a donation. If you had to buy these goods and pay the cost of goods sold and then sell them, the concept behind this exception is that you wouldn't make money. It wouldn't constitute a trade or a business regularly carried on in a commercial capacity. And that's what makes it different, is that all of this is donated property that you've received and are now selling. All right, let's turn to the sale of property. So let's say you own a building and you sell it. It can be exempt from unrelated business income. It depends on the structure of how you purchased it, why you purchased it, um, if it's a part of your ongoing activities to buy and sell properties. So you kind of have to take a step back when it comes to the sale of property and really look at the details. So I can't just give you a broad definition of, oh yeah, that's just fine. But if you've had a property that you've been operating for years and years, and now you're moving into a new building that you did a capital campaign and you're moving into this new building and you're going to go and sell that property, it's not going to generate unrelated business income for you. When you're talking about inventory or personal property, that's a whole nother story. And that's a different issue. So first I want to also point out that I skipped actually rents from real property. So let me go back to that. Rents from real property can be unrelated business income and sometimes are not. So if you own the property outright or you're renting the property and then you sublease it and it's not debt financed in any way, then it doesn't generate unrelated business income. However, if you have a mortgage on a property, oh, and I need to go back to that before I get into if you have a mortgage on the property. If you own the property outright, if you rent the property and then you sublease it or you rent it out, it may not be unrelated business income, but you have to make sure that that doesn't include any personal property as part of that rental, because personal property must be separated from rental of real property. Because in addition, you have to make sure that no services are provided with that rental. And when we talk about services, we're not talking about making sure that the lights are on outside. We're talking about maybe there's a receptionist on the first floor, and that receptionist handles calls for your organization as well, or welcomes people into the building and tells them where to go to come to the renters' offices. So if they're acting in a way that is a service to the organization, to the company that's renting the space, then you have to be, then it would constitute unrelated business income. Now, if you're going to provide that kind of service, you could do that as a separate contract as well. So you can have your rental and there's no services provided. And then maybe if somebody wants those services, you could enter into a service agreement with them. And that could generate unrelated business income depending on what that service is and what your mission is and so on. And you have to look at that. So the components for renting real property is: one, do you own it outright or do you just lease? Two, are you providing any personal property? Like, are you providing office, equipment, and are you providing, furniture and things of that nature? And then third, are you providing services? So to the extent you're providing personal property and services, that could generate unrelated business income. Now, the other way that it could generate unrelated business income in the rental area is if it's debt financed property. So if you own a building, but you have a mortgage on that building and you rent out part of that building, you could end up with unrelated business income from that rental because it is mortgaged property. Now going back to the sale of the property. So sale of the property gets a little more complex. And since it doesn't happen all that often for our clients, we're not going to spend a lot of time on it. But just know that if you're going to sell tangible property, and I'm not talking about selling personal property, I'm talking about selling actual property, then you need to, sort of what I call dirt property, you need to be careful about whether it's going to generate unrelated business income, and just make sure you're handling it properly, dealing with any capital gains and other issues. And are you selling that property as part of a business? So if you're selling it as part of a whole business, then it takes on a whole different analysis as well. There's one other area that's not on this list that I do want to mention, and that is logoed items and messaging. And we're going to get into that a little bit later but as well, but I want to mention it here because a lot of our organizations sell logoed items. And I get this question regularly. Can you sell mugs? Can you sell t-shirts? Can you sell things that have the organization's logo, maybe their the tagline, maybe some positive messaging associated with your organization? And do you have to pay unrelated business income tax on it? Well, you have to run through the test, right? Is it a trade or business? Potentially, if you're doing it, it's not just a random one-time thing. Is it regularly carried on? Do you have a website where you're selling these items on an ongoing basis? Do you have a little store in your facilities where you're selling these things? And then, is it unrelated to your mission? Well, that's where if it's got your logo and it's maybe got a tagline or things of that nature, then it's likely to be considered related to your mission. Just like the Christmas card, the cards, the birthday cards, where you're talking about providing information that's useful to avoid getting cancer. There's a very famous private letter ruling in this area that's for Susan G. Komen Foundation, and they're kind of the queen of, she's kind of the queen of all of these kinds of activities. And there's a set of thinking that her ability to do this, or this organization's ability to do this, is a little broader than perhaps some others. But one of the things that I always recommend is making sure that there's some sort of educational component associated with it. Tell people about your mission. So I had a client that was a pet rescue group, and they wanted to sell collars and leashes and other things with their logo on it. And I said, well, that is a trade or business. You're going to do it on your website. It's going to be regularly carried on. And is it related to your mission? Well, yeah, you're getting your logo out there, but what else could you do to solidify that this was really mission-based? And so they sent with each purchase a card all about spaying and neutering your dog or your pet, and also information about how to keep pets healthy and things that you should think about. And so by doing that, they were helping to further their mission to avoid having animals be given up to shelters and others, because they could understand what is it that they need to do to keep an animal properly safe. And also sometimes they included the general annual costs to take care of an animal, so that people would understand and know that and learn from that. Next slide.
Well, then, before we go to the next slide, I have a question from the audience that I wanted to share. There's opportunity to kind of go through that 3-part test. She is asking, would tax payment be required for a fundraiser where the nonprofit sells tickets to an entertainment event? In this example, it's a comedy show, where the show is just put on once, or if the fundraiser is an annual event.
Robin, you want me? Oh, go ahead.
Yeah, so generally, and Madeline, jump in here too. Generally, a fundraiser is a one-time event. And so it's not going to be something that's regularly carried on. It's a random one-time event. It's not a trade or a business, and it's not regularly carried on. So there shouldn't be an income tax requirement. However, the sale of tickets to an activity like this would generate the requirement to collect sales tax and submit that under Georgia law, because it's an activity of entertainment. So you would have to pay sales tax, collect and remit sales tax to the state. Do you have other thoughts to add to that?
Sure. I would just say, touching on what if the fundraiser event turns annual? Usually a fundraiser that's once a year still is not considered to be generating income that's subject to tax. Those are not considered regularly carried on. But that is a really good question, and something to bear in mind, that there are unusual situations where there's significant time and effort that's put in to promote an event. And in that instance, it might be considered regularly carried on. So just keep that in mind. If this is something that you're preparing for 6 months, right? You're putting a lot of effort into this. There's a ton of promotion and there's a lot related to it. You might run into that situation, but normally fundraisers like this that you're talking about, you're not looking at a UBIT problem here. I also see, Sarisha, there's actually a second question here. And Robin, I think you might be touching on this later, but I'll read it anyway. We own our property outright. We rent our parking lot during evenings and weekends to an event venue. We have paid UBIT on that rent for years. Am I understanding that we do not need to pay UBIT on this rental income?
Yeah, and we are going to touch on that a little bit later. So I'm just going to hold that
Yeah.
till later on. Yeah, there's one more question. We're a faith-based medical clinic. Our mission is to share the gospel with the poor. We are considering offering fee-based consulting services to start up charitable clinics, but only if they're faith-based. So that's a complex issue. We actually have a separate webcast all about charging for services that I recommend that you watch, and perhaps Sarisha can put a link to that in the chat.
I can do that.
That'd be great. All right, and that was a really good point, Madeline, about, if you're preparing for this event for a very long time, there's a pretty famous case involving that scenario where they said, look, you're spending so much of your resources preparing for this one event that even though it happens once a year, because it's taking up so much of your energy and time and money to put this on, that it is considered regularly carried on. Most of our clients are doing things like an annual gala or a golf tournament, and that's like a small portion of what they do. So that would not qualify in that case. All right, so the next area we want to cover is passive income. And passive income is exempted from unrelated business income. And the reason for that is that the concept behind it is that it is not a trade or a business. There's no effort being put forward by the organization to generate this revenue. So, in the case of dividends, they're investing their money and with the goal of hopefully making money off of it, but they're not physically or actively doing anything to generate that revenue other than putting it into, some kind of fund or market or investment to generate those dividends. The same with interest and annuities. Those are all similar scenarios of not conducting those activities. Now, there is you'll note there is a footnote to all of this, and that is that these activities cannot be generated, or this income cannot be generated through activities of a controlled organization or through borrowed funds. I'm not going to get into that in detail because that gets fairly complex, but just know if you have dividends, interest, or annuities, and it's just your own, that it's not going to generate unrelated business income. If you have a controlled organization or you're borrowing money to make that money, then you might have a different scenario, and you need to be really careful and think that through and get legal advice. I'm going to spend just a minute talking about royalties. Madeline's going to actually talk about them in more detail when she talks about several other subjects, but from a big picture perspective, a royalty is where an organization sells or licenses the right to use its intellectual property of some sort or other property that it has. And it is not actively involved in the use of it. So, a common example is cause marketing, which she's going to go over, where again, this is passive activity. They're saying, hey, you can use my name, you can use my logo. We are going to have some quality controls. So we are going to make sure that you're not using it in those things improperly. But we are just getting the benefit of that, your use of our intellectual property. And so since no effort is put forth by the organization to obtain the income, it's just like holding stock or receiving income from interest in a bank account. So the key, though, is how much involvement the organization has in this license. The same is true with mailing lists rentals. So organizations can license the use of their list of their members or of their followers or clients. And as long as they're not engaging in significant activity with regards to the rental of those lists, then it would be considered passive income. And where it's passive, there's no unrelated, it does not generate unrelated business income because there's no effort being put forth by the organization to conduct this business. Any thoughts you want to add to that?
No, I'll let you keep going. I'll touch on the cause marketing piece in a little bit.
Okay. All right. So this next slide is really to help you think about these issues and to ask questions. And that's what this is designed to do. It's help you to run through the test. So remember, you always want to run through it. Trade or business regularly carried on, unrelated to your mission. So some of the key questions. What is being sold? Is it donated? Does it have a logo? Why are you selling it? What are the services you're providing with what's being sold? And who is providing those services? Is it volunteers? And then here are some of the examples that we've already talked about. The one thing we haven't talked about is the low-cost article exception. And that is really where you have a fundraising campaign in which you might get a token gift with a logo on it from the organization. You know, NPR does this, you know, in an expert fashion. They are really good at saying, if you give us $100, we're going to give you a tote bag with our logo on it. And there's specific rules about what constitutes a low-cost article. And we have we put out an article every year because the amounts change every year. And we put out an article every year on this specific subject. So in that case that we were talking about before about the Christmas cards, one of the things they tried to argue is, well, these cards, this box of cards is a low cost article. And the court said, no, in this case, it's not, because you're specifically asking the people who've received these cards to either pay the $3 or give it back, give these cards back, return them to the organization or the company that was selling them on behalf of the organization. And since they sent 3 requests to either pay or give the cards back, it wasn't a gift. The low-cost article has to be more like a gift that they're getting for participating in the fundraising activity. It's not a purchase of the item, which is what makes it different. And then we've already talked about rental property, but here's, you know, is the property debt finance, are services provided, and then also is there personal property associated with it? So that's just a good slide for you to look at when you're thinking about these activities. Now I'm going to turn it over to Madeline to talk about qualified sponsorship, corporate sponsorship.
Thanks, Robin. So qualified sponsorship payments are not subject to UBIT, but income from advertising is considered unrelated business income and would be subject to UBIT. So we're going to break out what each of those things mean so that you can distinguish between them. So a qualified sponsorship payment is defined as any payment of money, property, or services by any person engaged in a trade or business with respect to which there's no arrangement or expectation that the person will receive any substantial return benefit. So I'll break out each of those things in a minute, but I want to note that when you're making this determination, whether something is a qualified sponsorship payment, it's irrelevant whether the sponsored activity is related or unrelated to the organization's tax-exempt purpose. And it's also irrelevant whether the sponsored activity is temporary or permanent. When we're looking at qualified sponsorship payments, we're focused on whether the sponsor is receiving a substantial return benefit. So when we're talking about a substantial return benefit, they define it as, the IRS defines it as a benefit other than goods, services, or other benefits of insubstantial value or use or acknowledgement. So each of those things is considered not to be a substantial return benefit. So it's important to define what that means. Something with insubstantial value is considered to be something with a fair market value of no more than 2% of the amount of the payment. So what I usually think of with this is, let's say we have sponsors that are sponsoring a nonprofit conference, and the nonprofit is, let's say, giving out pens with its logo. So these sponsors are receiving these pens. A pen is certainly a return benefit, but it's a very insubstantial one, very likely under that 2% threshold, and is insubstantial and would not take that sponsorship out of being a qualified sponsorship payment because of that. The other thing that's not considered a substantial return benefit is use or acknowledgement of the name or logo of the sponsor's trade or business. So when a nonprofit is displaying the sponsor's name or logo in connection with the activity that the charity is putting on, that's only considered use or acknowledgement. That's not considered to be advertising. So going back to my example about the conference, let's say sponsor provides money to go toward an exempt organization's conference, and the exempt organization has a banner that says, "Thank you to our sponsors," and it has the sponsor's name and logo on it. That's just use and acknowledgement, and that's not considered a substantial return benefit. So the payment from the sponsor would still fall into that qualified sponsorship payment bucket and would be exempt from tax. Again, it's really hard to distinguish this from advertising sometimes, but a few things that do not cross the line into advertising, so still considered a qualified sponsorship payment, are sponsors' logos and slogans, like we just talked about, that do not contain any comparative descriptions of the sponsor's products or services or facilities. A list of the sponsor's locations, phone numbers, website, that's okay. And value neutral descriptions, so like a visual depiction of the sponsor's product lines or services. All of those things are considered just use and acknowledgement and don't cross that line into advertising. So that sponsor's payment would still be considered a qualified sponsorship payment and exempt from UBIT. So briefly talking about advertisements before we keep going to the next slide, payments for advertising a sponsor's products or services is considered unrelated business income and would be subject to tax. So when you're trying to figure out whether something is advertising, this is normally any message or programming material that's broadcast or transmitted or published that promotes or markets a trade or business. So think about something like a message that has qualitative or comparative language. You know, we are better than our competitor. Price information or an indication of savings, an inducement to purchase, sell, or use a company's facilities or products. All of those things would fall into the advertising bucket because you're promoting the sponsor's material or the for-profit's products. I should note that if a message contains advertising and a use and acknowledgement, typically the default is that it goes into the advertising bucket and would then be subject to UBIT. So just bear that in mind. If you have something that's both, unfortunately, that doesn't exempt it from tax, if there's any sort of advertising in there, you are likely subject to UBIT. So next slide, please. So Robin touched on this earlier, so I won't spend too much time here. But another thing to consider with when we're dealing with qualified sponsorship payments is sales tax. So as Robin mentioned, a sponsor payment might be exempt from UBIT, but if the sponsor is is receiving a return benefit, you may need to include sales tax in the value of the return benefit. So the example Robin gave, I think you said a gala table with a meal. And in Georgia, the sales tax would be applied to the tangible personal property, so the cost of the meal. And so the sales tax would need to be built in to the value of that meal. So just keep that in mind, that even though you may be exempt from UBIT, you may have to think about sales tax in situations like that. Um, just note that we have a webcast on corporate sponsorships and an article on do's and don'ts of corporate sponsorships. I could go on and on about this because this is just such a complex area. And one of the things that I frequently deal with is distinguishing whether something we're doing is whether something we're receiving is a qualified sponsorship payment. So I highly recommend you dig into this a little bit more because it can get very, very complex. Next slide. So talking about cause marketing and commercial co-ventures. Commercial co-ventures, which are also known as cause-related marketing, are usually seen as an arrangement between a charity and a commercial entity to raise money for the charity. So basically, the for-profit is using the charity's name as part of a sales promotion to sell its products or services, and then makes a charitable donation to the charity following the promotion. This can get very tricky. It's heavily regulated by state law. I know Georgia has regulations in place on this. So again, this is something you'd need to dig into. We're just skimming the surface here. But normally, if a charity has a passive role in the promotion, the income that the charity receives from the commercial co-venture is considered public support and is exempt from tax. If the charity takes a more active role in the promotion, now you might be triggering unrelated business income and it might be subject to tax. This may also trigger UBIT if the charity provides, again, any return benefit to its co-venture. So something like promoting the co-venture's name and logo on the charity's website in connection with the promotion. That's considered more active. And now you're looking at a payment that is potentially subject to tax. There's two ways that typically these arrangements are structured to avoid UBIT. The first being structuring it like a royalty payment. So the nonprofit is not participating in the promotion, but it essentially licenses its name and logo to the for-profit business, which the for-profit business can use in its promotion. And then ultimately the money that comes back to the tax-exempt organization is structured as a royalty payment because it's a payment for the use of that license to use the name and logo. So that's one way to avoid tax in a situation like this. You can also structure it like a corporate sponsorship agreement, like we just discussed. The charity could just use or acknowledge the sponsor's name and logo without talking about the promotion. And it's possible that kind of arrangement could be considered a corporate sponsorship as opposed to a co-venture and may be able to be exempt from unrelated business income tax. So next slide. I know we're running super late on time, close to time. So just briefly, I'm talking about the publication of periodicals and books generating UBIT. I'll say the UBIT implications largely depend on the context of the books and whether there's advertisements. I worked with an organization that published an annual periodical. It was related to the organization's purpose. And so the sales from that periodical didn't trigger UBIT because even though it was regular and published, I think it was monthly, it didn't trigger UBIT because everything in that periodical was related to that tax exempt organization's purpose. But that said, any advertising that was in that periodical, those payments were subject to unrelated business income tax because the sale of advertising within that periodical was not considered related to the exempt purpose. So Robin, I'll let you take over the other examples on this.
Thanks, Madeline. So we've already really covered membership lists and provision eating facilities. So I'm going to skip over those and just go to the question that was asked about parking decks. So parking decks are a little bit complicated in that they involve first physical property. So is that property debt financed? If it is, then if you're renting out your parking deck, then you're going to generate unrelated business income. But if you own your parking deck outright, then the question becomes, if you, let's say a lot of organizations, they use their parking deck during the week, but maybe on the weekend, it's an area where a lot of people go out and there's restaurants and so on, and they want to, and so somebody wants to license the right to use your parking deck. Well, the question is, are you providing services? If you have a facility where you are managing the parking deck on the weekends, and you're not just opening it up and letting this other business sort of take it over and operate it on the weekends, then it may generate unrelated business income. You have to really look carefully at the structure of the relationship, and you can try and structure it such that you're literally just licensing the use of the property on the weekends to them. You're not providing services to them. They just have the right to use the physical space and pay you for that usage. Then it may not generate unrelated business income. But parking decks can get a little bit more complicated. So you really have to understand the services being provided, how the parking deck is structured in terms of how the money is coming in. Is there anybody working at the parking deck to manage it if somebody can't get out? And all those sorts of issues need to be addressed. If it's just a flat open area and people just come in and out, and you would close it off on the weekends and maybe you leave it open and somebody else is managing that, that might work. So again, you have to look at all the various details to determine whether or not a parking deck would generate unrelated business income or not. Any other thoughts on that, Madeline?
No, I think you explained that really well. Those can get super tricky, and that was something that was a huge issue a few years ago. Unfortunately, is not anymore, which we're really grateful for. So, no, nothing else to add on that.
Yeah. All right. Well, that's all we've got, unless there are other questions that anyone has. We're happy to try and answer them.
There's been no other questions so far. We can stay on for maybe another minute. We're already at 1:02, so I want to be cognizant of your time. But to our audience, thank you so much for joining us today and the great questions. And thank you, Madeline and Robin, for sharing your time and expertise with us. Just to let the audience know, our next presentation will be on July 18th, and we'll be talking about conflicts of interest. So if you're interested in learning more about that, use the link that I just shared to sign up. And I don't see any more questions coming in, so I think we can wrap up. Thanks, everyone.
Thank you.
Thank you.